Welcome, everyone, to our NYU Law School U.S. Asia Law Institute's Asia Weekly Dialogue. We're privileged this morning to have not only a great topic, but also a wonderful speaker, Professor Simon Young, who's Associate Dean of the famous Hong Kong University Law School and the leading authority on today's subject of criminal justice, which is as pertinent as today's news with the sentencing of some of the leading political activists in Hong Kong. Before we get going, I want to introduce our U.S. Asia Law Institute Executive Director, Catherine Wilhelm, who has an announcement or two and will moderate the question and criticism period later on. Professor Young combines theory and practice. He's been a prosecutor or practitioner of law, I should say, in Canada of criminal justice before his return to Hong Kong. And in Hong Kong, he has been both a law professor of criminal justice and evidence law at Hong Kong University Faculty of Law. And he's also a practicing barrister in the criminal justice field. So he's up to date and he's well known as a commentator as recently as today's South China Morning Post. And I personally am eager to hear what he's got to say. We've asked Professor Young to talk for a while, maybe 15 or 20 minutes, and then I'll ask some questions. We'll have some exchange and then open the floor to the usual comments and criticisms and questions. So Simon, we're delighted to see you. Thank you for doing this. And as the Chinese like to say, I will learn from you.
Thank you so much, Jerry, for that kind introduction. And thanks to your colleagues in the Institute for this invitation. It's truly an honor. I think I should begin this talk with a little bit of context to talk a little bit about the criminal justice system in Hong Kong before the national security law. Of course, at one time, the justice system in Hong Kong was quite brutish. But that was some time ago. But I want to actually look at the modern criminal justice system. And it's good to start in 1991, because that's when we received our Hong Kong Bill of Rights, of course, introduced just before the handover by the British. And that gave rise to the beginning of constitutional rights protections. And then after 1997, we also had additional rights in the basic law. And this has had quite a significant effect on the development of criminal law and criminal justice. And in fact, I have described our system as a due process model of criminal justice. And that the already protective common law safeguards have been extended by the constitutional norms. And our courts also have a very strong power when it comes to constitutional review. They can strike down legislation for being unconstitutional, and they have done that with criminal legislation. So this is sort of the context after 1997 with our courts. But I would highlight another thing about our courts in their approach to human rights issues. They approach the issues with a heavy dose of common sense and pragmatism. So they don't usually let rights arguments sort of get out of hand. There's a lot of proportionality and restriction analysis that's done in quite a sophisticated manner. But at the same time, they draw upon jurisprudence from around the world and also international tribunals, particularly the European Court of Human Rights. The third important quality that I would highlight is, of course, the impact of our foreign judge on our Court of Final Appeal. That's extremely important. It's been extremely beneficial to us. And I think many of you will know that we've been having a debate about the the future of the foreign judge. But what we see in criminal justice is how they bring in the international influence, but also the tendency to be fairly liberal and protective of individual rights in that jurisprudence. So that's been quite important. And the last quality I'll mention about the context is that up to now, I've just been talking about the work of the courts. When it actually comes to criminal justice reform, Hong Kong has not been very successful in this area. We have actually seen very little criminal justice reform after the handover, partly because of problems with the legislature and dysfunction in getting legislation passed. There's very many different interests that are represented in the legislature. And so the government has in the past many years simply been very hesitant to put forward controversial legislation. And so there's good and bad about that. The good, of course, is that you don't get the kind of politicization of the criminal justice system that you see in some democracies, with governments sort of riding on a get tough on crime agenda. We don't see that. That's probably a good thing. But at the same time, you don't have constructive development and improvement of the law. And just to give you an example of that, when I joined the faculty in 2001, I also joined the Law Reform Commission Subcommittee on Reforming Criminal Hearsay. And although they now have a bill before LegCo, but it's been almost 20 years and we still don't have reform in that area. So reform is very slow. And so with that perspective, suddenly we get thrust upon us literally almost overnight, this national security law, and done in a way that I would say is shocking, simply because it's so unlike what we're used to with law reform. No consultation at all. We don't get to see the draft of the text, no input at all. And then it's immediately, according to their plan, is imposed on us. So I think both shock, but I would also say somewhat awe, standing in awe to see this process take place, simply because of what we've had locally in Hong Kong with the inability to reform our laws, and to suddenly see this new piece of legislation just created in very short time and then enacted. I think one has to sort of stand in awe of that sense of authority. So when one looks at the law, one does see that it wasn't a straight cut and paste from the Chinese national security law. One does see that there was some care and attention taken to try to customize this law to Hong Kong circumstances. And one can see that so clearly simply by comparing the Hong Kong offense of subversion with the offense of subversion under the Chinese criminal law. There's a lot more detail in our law, and there's an attention paid to norms of having mens rea, etc. So one has to give some credit to those who drafted this law, that they did try to pay attention and to come up with a customized law. But I want to now just briefly identify 5 challenges to criminal justice that have been introduced by this national security law, and we can discuss them in greater detail later. The first is what I describe as the challenge of interpretation. Again, this is new for us because although we have had national law imposed on Hong Kong, never has it been in the form of criminal law. It's been, for example, laws concerning nationality, the garrison law for the PLA, and also the law of the sea. This is the first piece of national law of criminal law that has come in through this Article 18 mechanism. And what that means, of course, is a law of the National People's Congress Standing Committee means that it's the Standing Committee that has the final power of interpretation. So it's created some initial confusion about whether our courts can interpret and how they would interpret. But so far, we have only had one court decision looking at the substance of the law, and the indications from that judgment, it's in the case of Tong Yin Kit, the indication from that judgment is fairly positive in the sense that the two judges of the Court of First Instance said that we're going to apply common law approaches to the interpretation of the law, and we will take into account human rights norms in the same way they do with other criminal law legislation. But of course, the elephant in the room, of course, is that any time the standing committee could come in and interpret this law, which they could not do with our local legislation. They can do it, of course, with the basic law, and now they can do it with the national security law. So that's sort of hanging over our heads. We would hope that they exercise that power of interpretation with restraint, and that goes also for the Hong Kong executive government as well in seeking any interpretation. But if the practice is consistent with how they interpret the basic law, then they have in the past exercised a fair degree of restraint, and probably only if it really matters. For example, if many people were to be acquitted of certain offenses and the matter has gone to the Court of Final Appeal, then perhaps they might intervene at that point. It's too soon to tell whether the system of designating judges, so there's a system under this new law of designating certain judges who can only hear national security cases, too soon to tell if that will give rise to any problems of either bias or interpretation. But one has to watch this carefully. The power to actually appoint the judge to hear the case is still with the judiciary, with the judiciary. But of course, the risk is if the designations are manipulated, if there's only a very small number of judges who are designated to hear the case, then there might be possible concerns about bias or having certain judges who may have a certain inclination or approach hearing cases that might be of some concern, but it's still early days on that. The second challenge is what I describe as the challenges to ensuring a fair trial, because in the law, there are specific provisions that act as exceptions to some of the norms that we have for our trials. So for example, there are provisions about having closed door trials. There is what appears to be a presumption of detention. So contrary to the presumption of bail that prevails now under our ordinary law, there is also the exception to jury trials. So in cases that go to our high court, the Secretary for Justice can issue a certificate and turn that jury trial into a trial by 3 high court judges, which is unusual. We've never seen that before in Hong Kong. And there'll be questions even about, do the judges have to be unanimous, or will 2 to 1 satisfy for verdicts? We have no idea. There's no guidance in the law on that. And then there's also concern about certificate evidence. So for certain, if certain questions arise about whether something is an act concerning national security or if it's a state secret, then the Secretary for Justice can just issue a certificate which would be conclusive and binding on the government. That's also somewhat of concern, because certificate evidence, depending how widely you define it, it could basically decide the entire criminal trial. So that's something that is of some concern. I would say that for most of these issues, our courts are well equipped to do the necessary balancing. For something like open justice, it's already in our Bill of Rights, Article 10. And it talks about possible exceptions, but our courts will, they will be able to apply the usual principles of necessity, proportionality, and probably it won't create too much of a problem with these specific issues. We've already seen on the question of bail that the court in Tong Yin Kit has already looked at this issue and has said, this is not a complete denial of bail. It simply says that if someone who's charged with a national security offense wants to obtain bail, then the court needs to be satisfied that if released, they won't commit another national security offense. So that's an issue in all cases of bail, whether someone will go out and commit other offenses. So it's simply highlighting this. And what the court says, which I entirely agree with, is that in most cases, this provision won't actually make a lot of difference, because the court's already looking at the risk of this person committing other offenses. Um, and the court, said that this is just, a common sense kind of interpretation, looking at the substance of the law. The third challenge is a more difficult one, I think. It's the challenge of disproportionate penalties, because the scheme of offenses introduces sentencing provisions that we have never really seen before. There are tiers of minimum punishment. So, for example, for the offense of secession and subversion, a principal offender is to be sentenced between 10 and life, 10 years imprisonment and life. We have, other than murder, which is a mandatory life, we have no other mandatory minimum term of imprisonment under our law. So this will present some challenges for our court. And it won't be an obvious case of unconstitutionality, because in fact, I have to say, the scheme is set up in a very sophisticated manner. There are different threshold, different tiers of punishment depending on the seriousness of the case, depending on the role of the offender. And there are these safety valve. There's a safety valve provision where the court can show some leniency, and it's unclear to what extent they can depart from the minimums, but it looks like they can if you have an offender who has withdrawn from the offense, has surrendered to the authorities, given a full account, has provided assistance to the authorities. These are, of course, things that you want to encourage offenders to do, and our existing law of sentencing already provides discounts for sentencing. So it may well be that if these can actually take the sentence below the minimums, it might well be that the courts will find this justified. So they introduces some novel questions and very interesting questions of sentencing law, because our courts have held that under the basic law, under Article 28, there is a protection against arbitrary imprisonment. And arbitrary imprisonment could include disproportionate sentences. So there's a sort of possible head-on collision with that right, which our courts will have to think carefully about. The fourth challenge is the challenge of warrantless police powers. So this new law introduces some new powers for the police. In fact, I have to say a considerable extent, to a considerable extent, because in addition to the 66 articles of the national security law, we were given within a week a 200-page set of implementation rules, which sets out police powers in 7 distinct areas. I'll just highlight a couple of areas that I think could be very controversial. One deals with surveillance and interception. These are powers conferred on the new police unit within the Hong Kong police. The power of surveillance and interception is controversial because it's a power without any prior judicial authorization. There's no need to go to a court to get these orders. It's the chief executive who has these powers, and in some cases, a senior police officer. Now, why it's controversial is because we had a round of litigation in around 2005, which led to the unconstitutionality of the colonial powers, which also conferred a power on the governor and then the chief executive to authorize interception and surveillance simply on the basis of public interest. And in our court cases in 2005, our courts said that that was unconstitutional because they did not amount to legal procedures under the basic law. It was just an arbitrary conferral of power. So that jurisprudence will have to be tested under this new law. And there are, of course, important differences under the previous power that was given to the governor and under this new power, because under the new scheme, it's much more detailed, and there's no question that it is law. There might be a small question, but I think generally speaking, it's in a much stronger position than under the previous telecommunications ordinance. Very detailed scheme. There's lots of safeguards in there. Coupled with more recent case law from our Court of Appeal which has said that generally speaking, when it comes to our privacy right protections, searches have to be authorized by a court, generally speaking. Um, and so one has to take that jurisprudence together with the 2005 jurisprudence to see how a court will find with this warrantless power of surveillance. It'll be fascinating to see what happens here. The other power, of course, is the extensive power to take down online information. Again, we've never seen this before. We have no pre-existing scheme of how this can be done. But again, it doesn't involve judicial authorization, and it's very extensive. It identifies various different service providers and also the publisher of information, requiring them not only to take down information that may endanger national security, but also to provide information as to the identity of persons who may have uploaded and written the information on the various systems. So those powers could also be subject to challenge. Now, finally, I want to talk about the challenge of jurisdiction. And in this, on this issue, there are two aspects. The first aspect, of course, is the extensive extraterritorial jurisdiction that is conferred in this piece of legislation. Again, something new for Hong Kong. We have very few extraterritorial laws. This, on the other hand, as I think many of you know, basically prescribes these offenses and they can be committed pretty well by anyone around the world. If it's committed by a non-permanent resident outside of Hong Kong, it has to be an offense against the Hong Kong SAR. Hong Kong permanent residents can commit these offenses anywhere in the world. So look, national security laws, it's probably not too unusual that there would be a conferral of some extraterritoriality. The other issue really is then enforcement. I mean, it's one thing just to confer the extraterritoriality in terms of crimes. How are you going to enforce it? And the reality, of course, is we've seen about 9 or 10 countries suspend their extradition treaties. Now, something else that's not well known is we hear a lot about the suspension of the extradition treaties, but these countries have also suspended their mutual legal assistance treaties with Hong Kong. And what that means, of course, is if you want to gather the evidence from abroad with the relevant 10 or 9 jurisdictions, you're not going to be able to resort to those treaties. If you do it by other means, that's potentially a challenge on the basis of abusive process. But then, of course, one might say, well, those treaties are suspended now. Maybe it wouldn't be such an abusive process to provide the evidence by other means. So this will give rise to some interesting issues. For example, maybe the law enforcement try to share information while these treaties are suspended. There will be endless challenges in that regard. Now, the last challenge of jurisdiction is, of course, the conferral of this jurisdiction on the new mainland office to prosecute and investigate cases in Hong Kong and basically to take them back to the mainland for trial. Again, this has never happened before, at least not according to law. We've heard about cases involving booksellers and tycoons who were allegedly abducted. And so this will be a way to do this according to law. But the way it's written in the legislation, I think, is really quite interesting. It is repeatedly emphasized that it has to be, even these mainland officers have to act according to Hong Kong law. They have to act according to the mainland law, and the rights of individuals, rights to counsel, and other rights during the process have to be respected. And I assume that also includes while they're in the mainland as well, if they're acting under Article 55 jurisdiction. So this is an interesting possible new development whereby this national security law may in fact confer greater rights on individuals who are tried on the mainland. Now, of course, oversight and enforcement is another question because the law says quite clearly that the Hong Kong courts have no jurisdiction over these mainland officers if they are acting in accordance with their duty. That's a very interesting sort of rider there, because of course I think our courts will not shirk from actually assessing whether they are acting in accordance with their duty, and also whether there are other sort of jurisdictional clauses our courts could assess. So they're not, I think, complete ouster clauses. Our courts may be able to come in and to look at maybe jurisdictional issues. So I'm going to stop here, Jerry, and I'm very happy to go into greater depth on any of these topics or other topics.
You have given us an admirable, eye-opening introduction to the problems of prosecution under the new national security law. And I want to pursue some of these important questions because I honestly need enlightenment, even though from afar, like others, I've been trying to study what's taking place. But could you say something also about the ongoing prosecutions, which are so far quite a few, including today's sentencing of people under the pre-June 30th criminal justice system in Hong Kong? You've had a huge number of people who've been detained, 10,000 perhaps, in various reasons. So we'd like to hear a little bit about how have these cases been handled, and have they been affected by the arrival of the national security law, at least in terms of affecting the atmosphere, the procedures, the exercise of discretion. The whole system of Hong Kong justice is now under really challenge, even before getting to the questions you properly raise about the new national security law.
Yeah, this is a big topic, and so I'll just sort of make a few points. Let me just talk about perhaps how the national security law has impacted the overall course of charging and prosecuting. I think probably the biggest impact is simply in emboldening both police and prosecutors. And particularly, we're starting to see charges under the old English sedition laws. One wouldn't have expected to see that before the national security law. So it looks like they're really looking into their toolkit to see, what might stick with prosecutions. So we're starting to see that. There's now questions. There's in fact going to be, I think, a decision tomorrow whether the person who's been charged with sedition, which is the old English law, whether those cases have to go before a designated judge. And I think government has a good argument to say that they actually do. So we're starting to see how the old or existing, let me put it this way, the existing national security laws are now being aligned with this new national security law. And in fact, that's probably what the central government intended. I mean, you already have existing laws. This is not meant to replace those existing laws. It's meant to complement, enhance them, and there's supposed to be more national security laws to come in the future. But I want to talk a bit about some of the other cases. So what we're seeing in terms of the cases of the protesters is, of course, we are seeing these cases slowly moving forwards. About 10,000 people have been arrested. As I understand it, more than just about 2,000 have been charged. So there's still quite a few that may be charged in the future. One topic, in fact, it relates to the South China Morning Post article that I and two other Hong Kong U colleagues co-authored and is published today, is about the exercise of discretion to, particularly when it comes to young people, to not actually go ahead with a prosecution if it's not in the public interest. And this is an issue that we thought would be good to bring up because of the chief executive's policy address. She actually has a paragraph where she calls upon the police to exercise discretion for people who are under 18, if the case is minor, and if they're prepared to accept responsibility, if they show contrition. Um, our response is, well, that's fine and good for the police, but what about those who are under 18? And what about if someone has actually already been charged? As we all know, police cannot withdraw a charge. Once it's in the hands of the prosecutors, the police are only witnesses to the case. So she says nothing about that, maybe because under the basic law, prosecutions are to be free from any interference. So maybe she didn't want to say anything that may have sounded like interference. But nevertheless, our article is basically to say that the prosecution need to maybe show some mercy as well with young people generally, not necessarily just those under 18. So that, unfortunately, I don't think we've seen very much of. And it seems like they're taking quite a hardball approach with these prosecutions. I don't know the exact statistics, but it may well be there are cases where there's not enough evidence and they're not proceeding. But we're also seeing that there's quite a few acquittals. We're hearing many magistrates, and I guess this is testament to their independence, coming and acquitting individuals because simply the evidence is not enough. And in fact, it's not very easy. If you imagine the commotion and the chaos that was occurring on the streets at the time, it's not particularly easy to gather evidence that's going to prove the case beyond a reasonable doubt. And with rioting, of course, you have to prove a common intention, that you're actually in common intention with those who are maybe acting a bit more aggressively and violently. So we're seeing the acquittals, we're seeing, and then of course there are many other prosecutions involving very leading figures. Those cases are still proceeding. My former colleague Benny Tai, his appeal I think is coming up soon in the Court of Appeal. So these are cases that are just still making their way through the system.
There are so many issues one can raise. It's an exercise of discretion on my part just to decide which to begin with. But I'm very interested in the prosecutorial question. There's some evidence that in the public prosecution's office under the Secretary of Justice in Hong Kong, there is considerable dissension. And I used to be a prosecutor in Washington, D.C., and I know that sometimes you get into understandable controversies. And I'm wondering, has the suggestion of the Bar Association that prosecutors also exercise this discretion in the public interest rather than mechanically prosecute any case that on its face seems to have sufficient evidence, has that been making any impact in the Office of Public Prosecution? Do we have any sense of public ventilation of what's going on? I know the Secretary for Justice, Teresa Jung, was really an expert on the arbitration of construction contracts, and she's a well-trained engineer as well as a lawyer, but I don't recall her having much experience with criminal justice. And I'm wondering who is controlling the decision in the Department of Justice. Is it higher level influence from above? Is it the Secretary of Justice? Is it Director of Public Prosecutions? What do we know about who controls this, especially now that you have a special national security unit within the Public Prosecutions Office, and how that operates? We don't know. Is there any light you can cast on this crucial element of who is getting prosecuted and for what and for how long?
Yeah, I think it's most unfortunate. There's not a lot of transparency as to what's going on. Of course, we heard about the episode of the current Director of Public Prosecution, David Leung, saying that he was leaving the office, which will be happening very soon. And surprisingly, we don't have an announcement of who's going to be taking over yet. We haven't seen any advertisements in the newspaper, so it looks like they're going to fill it in-house. We don't even know who is the head of the special unit. That hasn't been made publicly known at all. Has there been any statement about who's calling the shots? No, but we do know that this has been a controversial issue in the past. In fact, in previous administrations, there were some calls for maybe an independent director of public prosecutions. So this is not a new issue, but we do know that the Secretary for Justice can make these decisions because she is the head of the Department of Justice. But there's a lot of delegation given to the Director of Public Prosecutions, but it sounds like from this dispute with the current DPP that there may have been some disagreement on some certain prosecutorial direction or decision. We don't know the details. And so it's still, up in the air. On the issue of discretion, unfortunately, it's probably a case where the police would actually would be accommodating and would like to see, they wouldn't oppose discretion, but they don't have the final say once the charge has been laid. And speaking to some police officers, they actually have some sympathy for protesters, seeing them sometimes as victims, getting caught up in larger things. If they had the authority, they probably would be prepared to exercise this. But what we don't see is any statement from the Secretary of Justice or the Director of Public Prosecutions with that same message, which is most unfortunate because we have seen it in the past with other directors of public prosecutions.
In looking at the question of whether in cases that are not to be tried under the new national security law, the new law nevertheless has an impact. One has to note the recent extraordinary attempt by the prosecution authorities in Hong Kong to have the judges who are going to handle a regular pre-national security law case subjected to the criteria for selection that the judges in national security law cases are to be selected by. Can you say something about that? That seemed unusual. We're told all the time that we don't have to worry about the new developments in Hong Kong because we have the tried and true independent courts in Hong Kong, certainly to handle pre-national security law cases. And yet the Department of Public Prosecutions seems to have tried to get only certain judges selected for these pre-national security law cases rather than have selection done in the normal manner. Could you say something about that?
So I referred to this earlier. Now, just to be clear, if the case has to go to a designated judge, the actual judge that is selected for the case is still made by the judiciary. So it's not the executive who's actually picking the judge for the case. But what I was saying earlier is that the question of other offenses that are not contained in the national security law, but are what we would still describe as national security offenses, for example, sedition, do they have to be tried by a designated judge? My initial reaction when I heard this issue was, of course not. It's only the national security law offenses that have to go before a designated judge. But looking at the law closely, I think government has a good argument to be made. Because when it talks about what cases have to go before designated judges, they talk about offenses that endanger national security. And that's a general description. Elsewhere in the law, when they want to refer only to those laws, the offenses that are under the national security law, it will say offenses under the offenses endangering national security under this law. It will make it very clear. So if designated judges are to hear offenses endangering national security generally, there's a case that could be made that this case has to go to a designated judge. But we'll get a ruling tomorrow. All that was happening was really the district court judge, the chief judge, said that, well, who has to decide this? Well, let's allow a designated judge to decide it, just in case it has to go to the designated judge. Because if it doesn't have to go, sorry, if it had to go to a designated judge and we had a non-designated judge deciding it, there might be complications.
That seems rather odd, and
Yeah.
certainly it'll be subject to question. And it certainly shows that the national security law is changing the pre-June 30th criminal justice system for Hong Kong in a way that could be considered sleight of hand. If it takes an expert analyst like yourself in order to understand what's taking place, it's hard for the public to grasp. But we see the outcome. The outcome means that not every judge in Hong Kong will be able to decide a case that should be dealt with under Hong Kong pre-national security law. So it's another example of the reach of the new national security law. What about the attack on judges?
Yeah.
We haven't given much attention to that yet, but as I said, the assurance has always been given by the pro-Beijing forces that don't worry, we always have independent judges in Hong Kong. And as you point out, the new law makes certain restrictions on this premise. But apart from that, what we're seeing is in the media, a very strong series of attacks, often by the same people who told us, don't worry, the judges are independent. They're now saying these judges need to be reformed. And we got to reform them in various ways, and starting with public condemnation. And they don't like these acquittals that you've mentioned. They don't like some of the decisions on bail. They don't like what they consider light sentences. And there are proposals, even by a former member of the Court of Final Appeal, for reforming the judiciary in various ways and restricting the exercise of the court's discretion. Can you say something about that?
So these developments are new and of some concern, particularly because they are mostly from those who are in the report writing for the leftist media. And of course, we had Mr. Zhao Xiaoming also talking about reform of the judiciary in Hong Kong. But it was at a seminar where they were talking about the law. And so he didn't detail what reforms he had in mind, but simply talking about reforms. He did cite that former judge of the Court of Final Appeal, Justice Lytton. Look, of course, the judiciary, they cannot respond directly to these. Individual judges cannot respond. And so the common law norm is that it's usually for the Attorney General or the, in this case, the Secretary for Justice to defend the rule of law and to defend the courts. And so there's been a question about whether our Secretary for Justice has been doing enough to speak up for the judiciary. The Bar Association, of course, very recently, in fact, even suggested that maybe she should bring or consider bringing our prosecution for contempt. We've had these prosecutions before, scandalizing the judiciary. We still have that as a criminal offense. It was used against the media in a very spectacular case just after the handover. That's one possibility of how these things might unravel, but probably unlikely, given that the Secretary of Justice has been very quiet on these things. Now, in terms of the Chief Justice, of course, he has been coming out to try to say more about how the process actually works. He came up with a very long document about how the criminal justice system works and the basic norms and principles, including the presumption of bail. So I think that's partly the cause is perhaps there's ignorance in the community. And I think that's of some concern when you have these very dominant media and figures who are making these statements. We want the public also to, be aware of, whether this is accurate or not. And so the Chief Justice has been coming out to make these, provide the community with more information, and also emphasizing the importance of, the judiciary can be criticized, but it should be done with, reason and rationally. So, I think for the most part, many of these types of issues we get in other places as well. And in other places, you don't actually have the tool of criminal prosecution for contempt. But it may well be that, we are just trying to, we have to get through these more difficult times. And judges will just have to.
Wondering what is in the future here, because as you point out, the deputy director of the Hong Kong and Macau Affairs Office himself has called for unspecified reforms. And we've seen many suggestions. Is there much prospect that judges could be ousted from their tenure because they displease the political authorities? There have been some transfers of judges. Certainly one was noted because he made a controversial decision hostile to the government view. He's been promoted to a better paid position that doesn't allow him any longer to decide cases, and that aroused some concern. There's been a suggestion that recruitment of judges should take place on different criteria now, taking into account loyalty, patriotism, etc. It sounds a lot like the mainland. And what about the training of existing judges to make sure they understand the need for comprehensive central government control of Hong Kong despite one country, two systems? And there's been a lot of push for a sentencing committee or a committee to make sentencing guidelines. And we've seen examples of this in other countries, including the United States. I'm wondering, do you have any comments on any of this? Should we take it seriously, or is this all media eyewash?
Yeah, I think the design of our system helps to insulate judges and to sort of protect them from interference from the executive branch. So for example, decisions on appointment, the Chief Justice plays a very strong and influential role as the chair of the committee. Of course, the Secretary for Justice is also a member of the commission for the recommendation of judicial officers. But it's been pretty much left to the Chief Justice, particularly when it comes to appointments of deputy judges and also for foreign judges, identifying the foreign judges who will come and sit on the Court of Final Appeal. So things that are important that we saw recently is during Chief Executive Carrie Lam's answering of some questions as a result of the policy address. She was asked about this, about judicial reforms, and that's generally well accepted practice, procedural rules. If there's reform that affects the courts, it's for them to decide what reforms they might want to take. And so I don't see her proactively doing anything. Now, on the question of disqualification, this is quite important because we have seen this new standing committee decision, which resulted in the disqualification of several LegCo members. And in that decision, it said that there are certain things that have to be done in order to uphold the basic law, and things that should not be done. For four new grounds were specifically identified. In Carrie Lam's policy address, she said that she had to now introduce legislation to implement this. And in terms of the extent of that legislation, it seems like it's only going to cover LegCo members, legislators, and maybe civil servants. But she never mentioned judiciary or the judges. So again, it shows that if there's going to be disqualification, it would have to come by a system introduced by the judiciary itself. And there already is a scheme for removing judges. Generally involves a tribunal of judges themselves who would make a recommendation to the chief executive for removal. So as I say, that's a procedural mechanism, an institutional mechanism that helps to insulate judges and protect them from influence, executive influence.
I want to turn in the final minutes before we start our questions from the audience to some of the issues you've raised about the national security law itself. To me, the most interesting has been one that in light of last year's huge public protest against the attempt to extradite people to the mainland, the law, as you point out, now provides, without mentioning the word extradition, for taking people who should be tried in Hong Kong to the mainland for trial. And this is, in effect, de facto extradition, of course. And I wondered whether you would comment on that. As you point out, they've been slow to move on this. Indeed, it's a question of the speed of implementing many provisions of the national security law. Although there was almost an immediate, strange leak to the press by the government that a number of people were on the list to be arrested. I don't see any evidence of moving against them. And of course, we're particularly interested in the mention of Samuel Chu, who's an American citizen for the last 25 years, and who apparently has been listed as a target for arrest because of lobbying in Washington about the events in Hong Kong. And this relates to your mention of the extraterritorial reach of Article 38 of the national security law, which goes beyond the mainland's criminal justice law. Yeah. And I was interested, you point out quite correctly how carefully done the national security law has been in light of comparisons with mainland's own law. And that raises the question, why consciously would Article 38 try to control potentially what you and I are saying today? We could be charged, and certainly I, with colluding in terms of offending the security of Hong Kong. So this, I've given you a couple of questions here. And if you respond to those, then we can turn it over for questions.
Right. Well, let's talk about Article 55 first. That's the mainland exercising jurisdiction. So one has to look at the terms of that provision and also what some mainland officials have said about why they've introduced this. The terms, of course, say that either the office or the Hong Kong government can make the request, but the Central People's Government has to make the decision. So it's not simply that's solely decided by the office, the mainland office. The central government would have to make that decision and be accountable for it. The criteria, there's a three-part criteria in the law, and what it seems like is contemplated are those exceptional cases where Hong Kong is unable to act, it's too difficult, too complex, or that the risk is so great, the risk to national security. And what the officials have said is that the reason why this mechanism is there is so that Article 18, the part of Article 18 that allows for national security, national laws to apply when there's an emergency, it's so that those laws, that provision doesn't have to be activated, so that they can just deal with the individual case. So, with those assurances, I guess we can only hope that it will be a kind of a backup mechanism where Hong Kong, only in cases where Hong Kong is unable to act or the risk is so extreme, that they will invoke this jurisdiction. There's no reason to think that they're going to be using it on a regular basis or constant basis. I think they'll want to see how the Hong Kong authorities are able to respond. If it turns out for whatever reason Hong Kong cannot respond appropriately, then they might invoke it. We would hope that if it is invoked, that there is full transparency and that we are able to see what happens. And of course, as I mentioned earlier, there are these specific mention of protections for the individual, right to counsel, etc. That's of course much better than the abductions. And so we hope that they wouldn't have to resort to abductions anymore.
And it's better, of course, than people receive in fact in China if they're prosecuted on the mainland. Yeah. And it raises the question, however, of the police and prosecutorial exercise of discretion in giving meaning. For example, when you mentioned we don't have to worry because unless a case is too complex for Hong Kong, it won't be sent over there. Well, there's a similar provision with respect to the criminal procedure in the mainland about police have to turn a case over to the prosecutor in 3 days, but in certain circumstances, they can take a few days longer. But if it's too complex, they could take up to 30 days. That's an exception. And that exception has been turned into the rule. Yeah. So the police always take 30 days now. So I don't think the complexity argument is much of a protection. But let's finish off this initial discussion by why would the mainland try in Article 38 of the National Security Law to control behavior outside of China that they don't try to control under the regular national criminal law? I had hoped since June 30th in the various meetings of the Standing Committee of the National People's Congress, they would issue an interpretation to assure the world that they're not trying to control my freedom of speech in the United States, or what I say about Hong Kong, as long as I have that freedom under American law. But they have not taken that opportunity. And what you say about the care with which this law has been drafted makes me think this is an attempt to intimidate the world in its analysis and discussion of Hong Kong, even though, as you say, it can't possibly be enforced unless I pass through the Hong Kong airport.
Well, I think to compare this provision with the mainland criminal law, yeah, you're right, there is a difference. This is wider because what's lacking is the double criminality requirement. I think, as I understand the mainland extraterritorial conferral of jurisdiction, there also needs to be double criminality. I suppose the rationale for not having that is simply the thinking that, well, every country has national security laws. So every country, we can assume that every country will have a national security law, and there's no need to have an explicit double criminality requirement. So if we can explain that, then one can say that this is simply on par with the Chinese criminal law in conferring extraterritorial jurisdiction. And it's not really sending a message. They're just trying to make it complete with the mainland law. This being national law of criminal law, we should make the jurisdictional clauses the same. Maybe that's simply the thinking.
You know, that argument is often made. Why are people getting excited about a new national security law? Every country has one. Yes, but what is the content of every country's law? And what are the procedures and the punishments, etc.? So that argument, I don't think, can go too far, but it's an interesting attempt on their part, perhaps, to justify it. But I've talked too long here. I know we have an impatient queue of people who are dying to get your views on various issues. And Catherine, why don't you please take over on the questions?
Yes, thanks. Yeah, we have a very eminent audience out there, very well informed, asking a lot of acute and detailed questions. There are a number of them about this matter you were just discussing of Article 55 jurisdiction, bringing people from Hong Kong to the mainland to face prosecution there and trial there. And some pushback, Professor Young, to your assertion that those people brought from Hong Kong to the mainland would continue to enjoy the protections of Hong Kong law, and asking you to elaborate on how you see that happening, because there's some disagreement that there is actually a basis, a way of reading the law to accomplish that, in particular because of some of the provisions that specifically exempt those same offices of the mainland in Hong Kong from Hong Kong law.
So I'm not, yes, they have to comply with Hong Kong law. There are certain provisions that allow them some freer access. So inspections of vehicles, etc., they wouldn't be subject to the same constraints. I think the rationale being that the individual arrested should be quickly expedited back to the mainland for trial without any constraint. But other aspects of Hong Kong law have to be complied with. And if it turns out that they're abusing their power, that can be subject to scrutiny by Hong Kong court, because they wouldn't be exercising their duty in accordance with the law. And you can ask a Hong Kong court to look at that. But I think, I mean, what's probably happened with me is that I think what is interesting is because it has this connection to Hong Kong, where of course the media, will, be right on top of any kind of development, that there might be this greater need to account to the public in these types of cases. And there is actual provision in the provision, I forget if it's Article 55 or near Article 55, I think it's near Article 55, where it talks about the individual's rights, which begin right from the moment they are arrested in Hong Kong. So I think it just creates something new and perhaps interesting. Of course, it could all be nothing. It could simply be that the mainland authorities will just do what they normally do. But it may be that under the scrutiny of Hong Kong media and the Hong Kong government as well, that they might be more willing to act in a more responsible and accountable manner. We might have more transparency in these matters, particularly if it's a Hong Kong permanent resident who is arrested.
But just on your last point about the role of the media, that sort of presupposes that the media becomes aware of the action. And I'm wondering, specifically for these types of arrests or charges, but also more broadly, is there any provision that requires an annual or periodic accounting or disclosure overall prosecution? I think you've said a number of times already that there is not a lot of statutory requirements of transparency. I don't think there's a provision, correct me if I'm wrong, for saying that every year there must be a report to the LegCo about prosecutions, about invocation of Article 55. Why should we expect, I know Hong Kong's media is very aggressive, but why should we necessarily assume that they would be aware that somebody has been bundled into a car in the middle of the night and brought to the mainland for Article 55 treatment?
Well, the chief executive has to report to the central government. That's required under the National People's Congress decision. So one would hope that, of course, that would be an open report and people in Hong Kong would be able to see it. But it's correct that there's no actual provision which says the chief executive has to report to the legislature. Nevertheless, the chief executive under the basic law has dual accountability, accountable to the central government and also accountable to the HKSAR, and she does that through her reporting to the legislature and also answering questions of legislators. Right. So through that process, we can probably obtain more information about what's going on. I think she should be asked probably directly about whether, if there was a case taken under Article 55, whether the Hong Kong government would make that known, and to get her to say that that she would, simply because it affects something of public interest that we should know about.
But it also,
I just wanted to add, Catherine, as Simon says, we don't know yet how these cases of people taken to China would be handled. But we do know that there has been since August 23rd a case involving 12 Hong Kong people who were detained for seeking to escape to Taiwan, and they were detained in Chinese waters. And we don't want to forget them. And to what extent, Simon, do you think the treatment that they have thus far received casts light on the probable treatment of people who will be taken from Hong Kong to the mainland for trial under the new law? These people are being tried under present day mainland law, but they're almost forgotten now. Since August 23rd, they've been detained. And there's not much transparency. They don't
Well, I wouldn't,
have lawyers.
I wouldn't say they're forgotten. I think there are many people who are very concerned here, but of course, the authorities seem to not be able to provide a lot of information, and they don't seem to be able to provide much assistance to them. Not to suggest that they haven't tried. I don't think that's probably the case. I'm sure they've made attempts to do so, but it does seem that on the mainland side, there's no attempt to, provide any kind of, special treatment or special attention to their cases. They're simply, I suppose, treating them like any other case.
Fortunately, that's true, and that means they've been denied the right to their own counsel. They have no legal representation of their own choice, and I don't know that they even now have assigned counsel, people assigned to them against their will who are supposed to help them. Do you have any recent information on that?
No, I don't have any information. Well, the only recent information is that we heard that they had written to their families to try to reassure them. And of course, the suspicion is that it was all scripted. So that's all that we know about it. I think we also know that now that the case is now in the hands of the prosecutors. And so I guess a trial might be imminent. But that's all we know. But of course, I think their case is different from a case that would be taken under Article 55.
Right.
Because Article 55 says very clearly, those adjacent articles, the person has the right to counsel. And I think that's something that the drafters put in to try to reassure us. And in fact, I did a sort of count of the provisions in the law that sort of make reference to the rights or the interests of individuals. And there's something like 9 articles, right? So again, it's a sort of the specific attention that was paid to try to reassure us that individuals and their interests matter. So we can hold this to the relevant governments and to cite these in courts. These will actually speak volumes in the Hong Kong court. These references to protecting individual rights, because even the law itself says we have to take into account individual rights. So courts will give effect to that.
Mm. So there's also some questions raised about other spillover effects of the national security law on other types of offenses. You've made the point that there might be security offenses other than those under this law that are actually encompassed in some way or affected in some way by this law, that in ways that may not be clear to us yet. The question of appointing judges, a special roster of judges to handle charges that are brought under non-national security law crimes, is one kind of spillover you've discussed, but what other kinds of spillovers might there be? So for example, the other special apparatus of prosecution, the police, the special prosecutorial unit, the special surveillance powers, and so on that you've enumerated, that entire apparatus, does that also potentially spill over onto, for example, sedition charges under the old colonial rules?
So the key words to be looking for in the law and also in the implementation rules are offenses endangering national security. And as I said earlier, sometimes this will be qualified by saying offenses endangering national security under this law. That's, I think, reasonably clear. That tells us it's only those offenses in the national security law. But as I said, because the law makes that distinction, it seems like offenses endangering national security could be, said to encompass more offenses, right? Now, how do the courts determine what are the offenses endangering national security? Is it simply by reference to the offense itself, or is it by reference to the facts that are said to give rise to the offense? And from what I've heard about this case that's in the district court now, it looks like the court is looking at the underlying facts, which is probably the better approach, right? So you may have someone who's charged with sedition, but maybe the facts are such that you can't say that it endangers national security, right? So if you take a factual approach, then it's a narrower interpretation of that phrase, but it's also less certain. And it may well be that questions about police powers, which apply to offenses endangering national security, you have to go by virtue of the offense itself without necessarily looking at the facts. I don't know, but I think, this is now a very interesting I think development that we see, how this law reaches beyond the four corners of its 66 articles.
Mm-hmm. One very quick question for clarification. You spoke of there being about 10,000 arrests so far. Do you mean that these 10,000 arrests are specifically under the national security law, or 10,000 arrests that are connected with the past year of unrest?
Yeah, I should be clear. The 10,000 related to the protests, sort of starting from June of last year, about 10,000, and many of them are young people, and then many of them are even under 18. I don't remember the percentage. Now, in terms of how many people have been arrested under the national security law, we don't have a precise figure, not that I'm aware of, but I think it's somewhere in the order of about 30 to 50. And I think only about 3 people have been charged.
Mm-hmm. A question about prosecutorial discretion. Are there any institutional mechanisms to punish prosecutors if they overcharge?
Not really. I mean, you have malicious prosecution as a civil suit, but simply overcharging does not mean it's a malicious prosecution. You can argue possibly abusive process. That's a remedy you can have in defending against a charge. That doesn't necessarily lead to any disciplinary action. And so, of course, the civil service, the Hong Kong government itself will have disciplinary proceedings, but it's not simply because they've overcharged. That won't in itself be a ground.
What apparatus already might exist for public supervision of the prosecution? Does it simply rely upon the transparency that the DPP itself chooses to exercise, and whether or not the executive council or the legislative council choose to make inquiries?
There's no external body that's been equipped with that duty. Um, it sort of self-regulates. It self-regulates, but in accordance with well-established principles, well-established rules of the common law, and in accordance with the Constitution. We have case law which says that you can judicially review decisions of the prosecutor if they violate the Constitution. So you have these kinds of guidelines, but there's no external body that acts as an independent body that oversees them.
Mm. So we're relying on non-statutory norms, basically.
That's right.
Yeah. So here's a question about the criminalization of certain kinds of speech under the national security law. We know that people have already spoken about a chilling effect. We've seen the chilling effect, I think, in action. Is it at all clear to you what speech is considered criminal under the new law and what speech is protected?
So that's a great question, and the answer is no. Not clear to me at all. And I think this is going to be a very important area for the law to clarify, because my own thinking is that a lot of the arrests that are being made for people who are simply putting up a poster or shouting out, revolution of our times, etc. I'm very doubtful that that constitutes a crime at all. And unfortunately, many people think it does, and that's why it has given rise to a chilling effect. Of course, it doesn't mean, even if it doesn't constitute a crime, it doesn't mean the police cannot act in the name of gathering evidence, etc. But I'm very doubtful that this constitutes the crime of inciting secession, which is what many of these, the two people who've been charged, that's all they've been doing. Even the first fellow who had the motorcycle, he had the flag on his motorcycle with a certain slogan. I'm very doubtful that actually constitutes the offense of inciting secession. If you look at what you need to prove for secession. Mm-hmm. The other speech crime, of course, is advocating terrorism. Now, that's quite interesting because we don't have any other offenses that I know of advocating something, a cause, to be a crime. But of course, terrorism is a much more serious offense in terms of the need to have violence, risk of violence, unlawfulness, and harm. That offense, of course, quintessentially is a speech crime and violates the freedom of expression. So it will be an interesting question of whether it's justified restriction.
When do
connection, and could you say something about the newly established hotline that provides for anonymous secret accusations for people who suspect other people of national security violations?
Yeah. Look, there's not too much to be said, and I don't think it's going to turn out to be a very useful tool for the police. So far, we've heard that they've received, I think, in the first 1 or 2 days, tens of thousands of calls. Right? So, frankly, what they're getting are just really, I think, a reflection of the political divide that we have in the community, and so you probably get a lot of political expression in these calls, but not a lot of useful tips. So I don't think very much about it.
You said that it's possible that some of these charges that have already been laid for speech might not be found to actually constitute the crimes alleged. When that would be important feedback for the Hong Kong community to receive in order to be able to gauge more accurately which actions are legal, which are not, and to order their behavior and so on. When can we start to expect to see decisions in those cases? Is there processing following a normal timeline for cases in Hong Kong, prosecution and courts? And what, according to that timeline, then when could we start to expect judgments?
Yeah, so cases, generally speaking, are fairly efficient in Hong Kong. But of course, we've had the backlog of cases, and of course, we've had COVID as well, where the courts were shut down for a good number of months. So it's hard to now estimate timelines. But my guess, I mean, we have these 3 individuals who are now charged. I would guess probably it would take about a year for their trial to complete. And then there's the appeal process, and we may not get great clarity until the case has gone on appeal. So that will take another year and a half, maybe 2 years. And then if it has to go to the Court of Final Appeal, we're talking about another couple of years. So we're talking, maybe 5, 6 years before we get maybe a case from the Court of Final Appeal. Maybe sooner, but it's going to have to take some time.
There are a lot of questions about the extraterritoriality provisions. You said that this, you seem to imply that the application of extraterritoriality is limited by, with respect to non-permanent residents of Hong Kong, is limited by a requirement that the offense must be against the Hong Kong Special Administrative Region. But is this a limitation that has any real force? Because since this law is a criminal law of Hong Kong, wouldn't any offense under the law be an offense against the Hong Kong SAR? It seems like a circular kind of a limitation.
Just to give you an example, calling for we know that the offense of secession relates to separating any part of China from China, right? So not just Hong Kong, Macau, Taiwan. So it's very Xinjiang, and it's very broad. But if you're trying to assume extraterritorial jurisdiction, that qualifier about an offense against Hong Kong, I think, is quite significant, because it may mean that if you're calling for the independence of Xinjiang or Tibet, it may not have extraterritorial application. That's just a very simple illustration.
And is that your interpretation, or is that interpretation been shared by one of the mainland offices?
I've not heard. I mean, we don't get a lot of guidance on this, but I think it is just it's distinct that you see those words against the HKSAR for that extraterritorial jurisdiction, implying that this is meant to be a bit more narrower. The purpose is really things that endanger Hong Kong, but if you're calling for the separation of Tibet, you're not really endangering Hong Kong. It seems like a common sense application.
I see.
Yeah.
You mentioned that there were very few laws in Hong Kong that have extraterritoriality provisions. What other laws already exist that do have such provisions?
So our bribery laws, when it comes to Hong Kong officials, so Hong Kong officials anywhere in the world, if they receive bribes, we have sex tourism offenses, and that's, I think, common in many jurisdictions. But beyond that, also some of the conspiracies and commercial crimes. We have a criminal jurisdiction ordinance that deals with conspiracies. We also have common law principles. So if 2 people outside of Hong Kong conspire to commit an offense in Hong Kong, that would be a crime. It's not true the other way around, but directed at Hong Kong. But we've had a couple of cases from the Court of Final Appeal that have applied a very strong territorial principle, which is the common law principle. And even novel arguments.
Is it an offense to bribe the chief executive of Hong Kong?
Yes. Yeah, most certainly. Absolutely, yeah.
Because there's been some question about whether new legislation should be allowed to include her within the usual subjects of anti-bribery prohibition.
You're talking about Section 3 of the Prevention of Bribery Ordinance. Section 3 makes it an offense for any proscribed officer to basically receive any advantage or ask for an advantage. And the funny thing is that a prescribed officer means the core of government except for the chief executive.
Yeah.
But why it made sense to leave him or her out was because that provision says with the exception of permission granted by the chief executive. Right. So if you're going to include the chief executive, you're going to have to come up with another scheme. And that's what the former chief justice said. Andrew Lee said that you have to have a separate scheme. Now, Kerry, the chief executive, is saying something really interesting and new, which is that Beijing will keep her accountable. I think it's a really interesting development because it made me think maybe this might work. And maybe if your chief executive is taking bribes and committing corruption, could that be seen as a national security crime? Maybe we should write it into the national security law, and then Beijing can apply that.
Presumably, she and others in the Hong Kong government are subject to the new National Supervisory Commission that was established in 2018 in the mainland, that gives them the power to even detain and interrogate, surveil all officials as well as party members, etc. Catherine, we only have 2 minutes to go. I wanted to ask one final question that's very important about judicial review. We recently had the ouster under the order of the National People's Congress Standing Committee of 4 Democratic members of LegCo. Do they now have an opportunity, despite that, to go to court and challenge what the government has done? Or is there no longer judicial review of such an action?
Oh, no, of course they could. Of course they could. And in fact, it would be quite an interesting question, because there is nothing in our local law that allows you to kick out legislators like that in this way. To kick out legislators, you need to have 2/3 support of legislators and a finding that they are in breach of their oath. So there's actually already a mechanism to disqualify or remove legislators. So then, of course, the chief executive acted pursuant to this decision. So it's a decision of the standing committee, and she made an announcement pursuant to that decision. It may well be that that's as a matter of reality, it's going to be very difficult to succeed in such a judicial review.
So that means the courts are really being deprived of the fair opportunity to consider the constitutionality and legality of what has been done. That's been usurped by the decision of the standing committee of the NPC.
Yeah, I suppose so. But of course, it was all rather novel and unusual. I mean, it all stems from the extension of the term itself of 1 year.
Yeah, I was just using that to illustrate another successful, apparently, attempt to curb the independent power of Hong Kong judges. The standing committee seems to be engaged in a process of taking away the so-called power of final adjudication that the basic law allots to the Court of Final Appeal.
That might be a bit of a stretch, because the case could still have been brought and the court would have looked at it very carefully. Yeah.
Well, this has been a terrific session. It's just what we hoped for. And you're a great resource, Simon. And I hope we can call upon you in many ways to continue to enlighten us. Thank you very, very much.
Thank you very much, Jerry. Thank you to everyone. Thanks for all the questions.